Welcome once again to Lehto's Law. Here's Steve Lehto.
A lot of big news lately, and one of the biggest stories crossed my desk last night about 6 o'clock. And I got a bunch of emails from people who said, Steve, this is one you may want to take a look at. And of course, you guys are right. Gary, John, Jonna, Scott, Alan, and Glenn all were the ones who got it to me. And what we're talking about, of course, is the Michigan Supreme Court just struck down the governor's last orders regarding COVID restrictions. And so this is a controversy that's been going on for quite some time now. And I don't need to go into too much detail on this, except to tell you that at the beginning of all this, the governor of the state of Michigan, along with the governors of other states, invoked emergency rules. There were laws on the books of things they could do in an emergency. And our governor invoked those laws and passed a bunch of restrictions on how you could behave in public, what you can do out there, and so on, and how businesses would operate. And so a lot of people were upset by that, and a lot of people questioned whether that was legal or not. Was it legal or not? So I did a couple of videos on that, and I pointed out that the laws were on the books. One of the laws has been on the books since 1945. And I said, in essence, if you don't like that law, there's two things you can do. One of which is the legislature could write a new law to replace the old law, pass that, and then that become a new law. New laws replace old laws all the time. I said also, if you wanted to, you could take a case up to the Michigan Supreme Court or the U.S. Supreme Court, but the Michigan Supreme Court's a better bet, and ask the Michigan Supreme Court to review what's happening and ask whether or not this is legal. And the Michigan Supreme Court yesterday, in a ruling that is, I'm not making this up, 150 some odd pages thick, and I print on both sides, that's the only reason I can hold this in one hand, said that what was happening after the initial ruling was in fact unconstitutional under Michigan's state constitution. So there's a lot going on here, and I'm going to try to summarize it as best I can because it's 156 pages. And one guy who sent it to me actually said, Steve, I'm going to go read the opinion now. I'll get back with you. This morning I got up and I saw the email where it said, Steve, I just finished the opinion. Now, I didn't look at the timestamp to see how long it took him, but I suspect it was a lengthy time. So I actually sat down last night and this morning and read through the opinion. I also then went out and read some of the news coverage to make sure there's nothing I missed. And I'm here to tell you, this is the opinion from the Michigan Supreme Court regarding certified questions from the United States District Court, Western District of Michigan, Southern Division. And the case is entitled Midwest Institute of Health, PLLC versus Governor. And I have to tell you right off the bat, this is a very unusual procedural issue because the case that is before the Michigan Supreme Court is in federal court. And this is a very unusual process, but it's allowable, and this happens from time to time, but not very often. But we have federal courts, and we've got state courts. The federal courts are all across the country. They answer to the appeals courts, and the appeals courts, of course, go up to the Supreme Court. So Michigan has got federal courts here, the Western District of Michigan being one of the districts for the Federal District Court in Michigan. So if there's an issue of state law that is not clear-cut, a federal court can certify a question and send it to the state Supreme Court and say, this question is unsettled and we don't know how to rule because we need a ruling from you to tell us what the law is. Because, and I don't want to get too deeply into real heavy legal doctrine here, but there's a concept called the Erie Doctrine, E-R-I-E, like the Lake Erie, the Erie Doctrine. And the Erie Doctrine says that federal courts, when they sit in a particular state, if there's something before them that's a state law issue, even though it's a federal court, they'll follow the state law when appropriate. But how do they follow the state law if it's never been ruled on by the state Supreme Court? And so federal courts are allowed, if they want to say, well, here's what we think they would do. And they've done that in the past. But on something as important as these COVID emergency orders, the federal district court said, you know something, this is something that we think that the state Supreme Court needs to rule on, so we know how to rule on it as well. So the Midwest Institute of Health and a bunch of other companies and Jeffrey Gulick brought an action in the United States District Court for the Western District of Michigan against the governor of Michigan, the attorney general, and the Michigan Department of Health and Human Services director, challenging a governor's executive order. And they give the order number, it's 2020-17, which prohibited healthcare providers from performing non-essential procedures. And that order was issued by Governor Whitmer as part of a series of executive orders issued in response to the pandemic. Now, several other orders were issued after that, some of the previous orders expired, that becomes irrelevant here because the Michigan Supreme Court says we don't care which orders we're talking about. We're going to talk about basically all of them. And those orders were issued under two separate statutes. One was called the Emergency Powers of the Governor Act, the EPGA, and that was passed in 1945. So that was passed 75 years ago. The other one is the Emergency Management Act of 1976, and you can guess that was passed in 1976. On April 1st, 2020, the governor issued an executive order which declared a state of emergency. And under the first act, the 1945 Act, a state of emergency and a state of disaster were declared. She then also requested that the legislature extend the state of emergency and state of disaster declarations by 70 days, and they did that. They adopted a resolution extending the state of emergency and state of disaster through April 30th, 2020. Now, here's where the issue arises. When that time frame expired, she then declared a new emergency and issued a new executive order, and she issued more since then. So the plaintiffs in this case went into federal court and said, look, we have no dispute that those initial declarations of emergencies and disasters were appropriate. And the law says that she can declare an emergency and she can ask the legislature for an extension, which she got. But once that extension expires, if she is simply allowed to issue new emergency orders and say, well, it's another emergency, then theoretically she could do that forever. And of course, the other argument is, well, read the statute. What does the statute say? So you've got two different statutes, the 1945 statute and the 1976 statute. So the reason this particular plaintiff, the gentleman whose name I gave earlier, Jeffrey Gulick, brought this action is that he had wanted to get knee surgery done at one of these clinics. And that was considered to be elective surgery. And therefore, they said you can't get that because of the executive order saying you can't. So he filed that. And of course, that becomes a cause of action. He files it in federal court. And federal court then says, well, we're not exactly sure how the state Supreme Court would rule. So we're going to send it to them. So the state Supreme Court was asked to rule on two specific questions. So they certified the questions. Question number one, whether under the Emergency Powers of the Governor Act, the 1945 Act, Governor Whitmer has the authority after April 30th, 2020 to issue or renew any executive orders related to the pandemic. Number two, whether the Emergency Powers of the Governor Act and or the Emergency Management Act, the later one, violate the separation of powers and or the non-delegation clauses of the Michigan Constitution. Two questions. So the question is she allowed to issue another order declaring an emergency after that one date? And are those statutes constitutional? Not under the federal constitution, but the state constitution, Michigan's state constitution. So now here's the interesting part. It says the Michigan Supreme Court, in opinions by several justices, unanimously held. So I had several people email me and say, Steve, it was a unanimous decision. Well, it was a unanimous decision in one respect, in that all of the justices did agree on one point. They did not all agree in the same way. They did not all agree on all the points. So, for instance, the Supreme Court, in an opinion by Justice Markman, joined by Justices Zara and Clement on three parts, and on the fourth part by Justice Viviano, held. So you've got four of them agreeing, but three of them agree in one way, and the fourth agrees in a different way. And the second certified question is partially answered in the affirmative. The governor did not possess the authority to exercise emergency powers under the EPGA, the oldest one, because the act unlawfully delegates legislative power to the executive branch, which we'll get to in a second. But then it says, Justice Markman joined Zara and Clement, while Viviano concurred in part and dissented in part. McCormick was joined by Bernstein and Kavanaugh, concurring in part and dissenting in part, and concurred with Markman's opinion to the extent that it concluded certified questions, blah, blah, blah. But McCormick dissented from the majority's constitutional striking, and Justice Bernstein concurred in part and dissented in part, disagreed, and so on. So it's a very, very confusing opinion. And I'm going to do my best to distill this for you. But basically, it comes down to the fact that they find that she had no right to issue any orders after April 30th, 2020, and they find that the 1945 Act is unconstitutional. That's it in a nutshell. So I mentioned before, this case concerns the nature and scope of the state's public response to one of the most threatening public health crises of modern times, and this is the majority opinion writing here. In response to a global, national, and state outbreak of the severe acute respiratory disease named COVID-19, Michigan's governor issued a succession of executive orders over the past 6 months, limiting public and private gatherings, closing and imposing restrictions upon certain businesses, and regulating a broad variety of other aspects of the day-to-day lives of our state citizens in an effort to contain the spread of this contagious and sometimes deadly disease. First of all, and most news reports that I read about this opinion pointed this out. The very first footnote, the court writes, "Our decision leaves open many avenues for the governor and the legislature to work together to address this challenge, and we hope that this will take place." So in other words, the court's not saying the government shouldn't do anything. The court is saying the government probably should do something, but they just need to do it in a way that doesn't violate what we think you did previously, because we think that violated the Constitution. So they're talking about this one executive order that got passed, and it was on April 30th, 2020. The governor issued Executive Order 2020-66, which terminated the declaration of a state of emergency, a state of disaster, but immediately declared a new one. So the question is, when the first one and its extension that was granted by the legislature expired, does she have the right to declare another one? Okay? And I had several people bring this up to me. They said, Steve, if she's allowed to do that, theoretically, she could just do that forever. So first of all, I should point out that this is not the first time a court has ruled on this issue. Okay? In fact, I had several people send me links previously to other rulings in Michigan and other states. Said, hey, Steve, there's a lot of action going on here. Well, I knew the Supreme Court was considering this particular issue, so I wanted to wait till this came out. But you should know that previously, somebody brought an action to the Court of Claims, which is a state court here in Michigan, and argued that the governor did not possess the authority under the EPGA, the old statute, and so on. And that court specifically said she did, absolutely said she did. And a court of appeals upheld that order, okay, that ruling. So I had several people tell me in emails recently and before, and they say, Steve, but what she's doing is wrong. Well, here's the thing. If you think it's wrong, that's great. If someone else thinks it's wrong, that's great. But it's like a football game, okay? The referees make rulings. And once a ruling gets made, that's the ruling. And I've seen referees make bad rulings. I can think of a few right off the top of my head right now. But the point is that I'm an attorney. I tell you about the law, and I have to point out to you that the arbiters of the law are the courts. So when the Court of Appeals says we hold that this is a valid use of this law, unless it gets struck down by the Supreme Court, that is actually proper. So for the people who said, but Steve, it was wrong, at the time it was right. It became wrong yesterday. So this court writes, the governor's declaration of a state of emergency or state of disaster may only endure for 28 days absent legislative approval of an extension. So if the legislature does not act, the governor is obligated to terminate the state of emergency or disaster after 28 days, and that is what that happens. That is what happens. So now, the EPGA, though, is the big one. That's one that goes back to 1945. And the question is, does that give her the sweeping powers that some people thought she had? So, for instance, I'm going to read to you what it says. This is the statute itself from 1945. During times of great public crisis, disaster, rioting, catastrophe, or similar public emergency within the state, or reasonable apprehension of immediate danger of a public emergency of that kind when public safety is imperiled, either upon application of the mayor of a city, sheriff of a county, or the commissioner of the Michigan State Police, or upon his or her own volition, the governor may proclaim a state of emergency and designate the area involved. And then it talks about the fact that this has sweeping powers. So that's the earlier 1945 Act, right? Well, here's the question. Several people were making arguments in this matter, including people from the legislature who had filed their own action, and then the guy who wanted the knee surgery. And they said, for instance, that this statute doesn't apply statewide. it talks about the area involved. And if the area involved is important, well, it couldn't be referring to the whole state because the whole state's a state. But the Supreme Court says we disagree and do not find this to be a reasonable understanding of the law. Area is defined as a geographic region, according to the dictionary. And notice they did not use a black C, they used Merriam-Webster's. And the area involved or the affected area may comprise the entire state, or it may comprise some more localized geographical part of the state. So they're rolling right along there. And they're talking about how this statute does appear to do a whole lot of stuff. But they do say this is in fact the kind of thing this statute was designed to address. Given that COVID-19 has resulted in the deaths of many thousands in Michigan and hundreds of thousands across the country, COVID-19, in our judgment, can reasonably be said to imperil public safety. So this is one of the situations where if you didn't actually have the cheat sheet at the front of the opinion, you'd be reading going, hey, I think we won. But the problem, according to the Supreme Court, comes down to a section of the Michigan State Constitution that says specifically at Article 3, Section 2, the powers of government are divided into three branches: legislative, executive, and judicial. You might recognize those, by the way. It's the same division they have in the U.S. Constitution. No person exercising powers of one branch shall exercise powers properly belonging to another branch, except as expressly provided in this Constitution. So, as you can imagine, you have an executive who signs laws once they've been passed by the legislature. You have the legislature passing laws that get signed by the executive. You've got the judicial branch running the courts and then reviewing things that are put before them, trying cases and so on. So those powers appear to be fairly well defined. Most people think that, right? So the question then becomes, does the Michigan legislature have the right to pass a law giving power to the governor that would appear to be power vested in the legislature? And this is where the argument falls apart from the governor's side. Concerning the subject matter of the emergency powers conferred by the 1945 Act, it is remarkably broad, authorizing the governor to enter orders to protect life and property or to bring the emergency situation within the affected area under control. It is indisputable that such orders to protect life and property encompass a substantial part of the entire police power of the state. There seems to be no doubt that this power does extend to the protection of the lives, health, and property of the citizens and the preservation of good order and public morals. And the police power is legislative in nature. So what they're basically saying is that the legislature in 1945 passed a law, signed, by the way, by the governor at the time, that gave the governor too much power. But the interesting thing is that law has been in the books since 1945. And one of the problems that the Supreme Court has with this is the duration of that power. So if the law had said, if there's an emergency that lasts a week, the governor can take over for 1 week, straighten things out. But the law doesn't say that. So concerning the duration of the emergency powers conferred by the 1945 Act, those powers may be exercised until a declaration by the governor that the emergency no longer exists. Thus, the governor's emergency powers, according to the statute, are of indefinite duration. So this is a problem. The fact that the law authorizes indefinite exercise of emergency powers for perhaps months or even years considerably broadens the scope of authority conferred by the statute. So there's a problem with the fact that the statute appears to give the governor unlimited powers with respect to how long this emergency situation can be declared to be valid. So we accordingly conclude that the delegation of power to the governor to promulgate reasonable orders, rules, and regulations as he or she considers necessary to protect life and property constitutes an unlawful delegation of legislative power to the executive and is therefore unconstitutional under the Constitution. And they're referring to Michigan's state constitution again, because that Constitution prohibits exercise of the legislative power by the executive branch. So the fact that the powers conferred were listed as being either reasonable and necessary, or reasonable and necessary, does not actually get them around that problem. So they say that the fact that that section gives this unbridled power to the governor makes it unconstitutional. Now, we're going to get into a very rare area of the law here referred to as statutory construction. Statutory construction. And what we're talking about is how you read a statute or a law and how you construe it. Same root as construction. So we're not talking about how you build a statute. We're talking about how you construe a statute. So when you're reading a statute and it appears to be unclear in some way, how do you deal with the ambiguity, for instance? And one of the things that pops up here is, so you've got this act from 1945 that lists all this stuff that you can do and not do in an emergency if you're the governor. And the question becomes that the Supreme Court has just decided that one section of the statute is unconstitutional. Does that render the whole statute unconstitutional or just that part? And the courts will, as a matter of statutory construction, try to save a statute if it can be saved. So if there's 10 parts to a statute and one part is unconstitutional, if the other 9 are constitutional, they'll say, oh, something, we'll just strike this one portion. Makes sense. But the problem happens where occasionally you run into a situation where you strike a portion and the rest of the statute either makes no sense or that was the heart of the statute. So the Supreme Court goes into a long discussion on that, probably 10 or 15 pages. It says, in our judgment, the EPGA, the 1945 statute, is inoperative when we sever the power to protect life and property from the remainder. Therefore, the entire EPGA is unconstitutional in its entirety. So the entire statute gets struck down. So what they're basically saying is there's 2 statutes on the book. And the one statute says that the governor can invoke an emergency and declare an emergency for a short period of time and extend it perhaps with the legislature's help, and in that period issue rulings and executive orders. And in the original time frame, executive orders also, and presumably if the legislature didn't act, then she'd be stuck with this little short time frame here. But we have that situation where they said, okay, the first statute says that she gets that one time frame, boom, everything past that's gone. Now, the second statute, which appeared to have a lot of the same parallel grantings of power to the governor, they're saying that entire statute's unconstitutional. It's been in the book for 75 years, but it's unconstitutional. 1945 statute, unconstitutional. And so that happens. That happens. Now, it raises a couple interesting points, but one of which I want to point out to you. For instance, that I just hit the opinion after 48 pages of the initial opinion of Justice Viviano's opinion, concurring in part and dissenting in part. And that's what you have for the rest of this, where it's concurring in this, dissenting in that, and trying to figure out what they're agreeing on and disagreeing on becomes very, very difficult. But that happens a lot also. Okay, it's not often that you see a 9-0 opinion from the U.S. Supreme Court or a 7-0 opinion from the state Supreme Court. And I know some people are going to say, but Steve, it appears they were 7-0 here on one narrow issue. And they were. They were, in fact, if I could find the page, I don't know if I could or not, but if I could find the page, there it is. Wow. Once in a while I get lucky. On the concluding page of the majority opinion, which is signed by 4 judges, it says, we note that majorities of this court have joined in full Part 3B of this opinion and Part 3C2. The former is a unanimous holding of this court. So with respect to Part 3B of this opinion, it was a 7-0. It was. But the others, not so much. And this gets us to a situation where I've mentioned this before, and I get people who comment on my videos and get very, very angry with me. And they yell at me about the law. And they'll say, that law is stupid, you're an idiot. Well, those are 2 different things. And don't get me wrong. They could both be true. But one being true doesn't make the other true. The 2 are unrelated. I don't pass laws. Okay, I'm an attorney. I'm here to explain the law to you as best I can in Michigan. So I've said repeatedly, if you don't like a law, people don't like a law, if there's this huge groundswell of support supposedly for people who like this or don't like that, they can get together and ask the legislature to rewrite the law, pass a law, or strike down a law. They do it all the time, okay? So they can do that. That's what legislatures do. There's Schoolhouse Rock videos on this that are a minute long and explain it to you. It's not that complicated. The legislature can rewrite a law. So the fact that there's a law in the books since 1945 that was unconstitutional on its face makes you wonder why it was there for that length of time and no one noticed it before, or what's going on. Because the next point I've often made is if you don't like the law, you can go to court and challenge it. That happens all the time also. That's when most laws get struck down by courts up on challenge. So this law, or this group of laws, and the executive order is this one, were challenged in a variety of courts across the state. State court, court of appeals, and so on. And now here we have this unusual procedural move, but perfectly legal, and it's happened before, where someone filed a court case in federal court, and the federal court asked the Michigan State Supreme Court for guidance, and the Supreme Court then ruled. Theoretically, if somebody had the same issue in a lower court in Michigan and had appealed it, I believe somebody had, they could have appealed that and brought that up and asked the Supreme Court to rule on, in essence, the same issues. So the Supreme Court of the state can always rule on and strike down a law. And I'm not saying that they did anything wrong here. I'm saying they did what they're supposed to. That's their job. That's their job, okay? So I said before, I forgot which video I said it in, but I know I've said it more than once, that there's two ways that this can be addressed, legislatively or in the court system. And so here we are in the court system. So now I've had people who emailed me and said, Steve, but this proves you were wrong the whole time. No, I wasn't. No one is wrong until yesterday. And that's how it works. That's the weird part about our court system, is that the law can be a certain way for years, decades, 75 years, and then a court rules and says, no, this is the law. The law back here was still the way it was. And you might say, but Steve, if the law wasn't invoked, then what's the difference? Oh, I can tell you the big difference. I've mentioned before there's a law called the Consumer Protection Act in Michigan that the Michigan Supreme Court just struck down and basically said, this law doesn't make any sense, therefore it has no power. And they dismissed it. They didn't overturn it in the sense that they can't rewrite the statute, but they issued a ruling where basically no one can bring an action under the Consumer Protection Act. No individuals can anymore. And that's what it's designed to do. And for decades, attorneys had filed lawsuits and gotten relief and had cases turn out where they'd gotten stuff for their clients under the Consumer Protection Act until the Michigan Supreme Court struck it down and said, we don't like this law anymore. And now it's gone. It's gone. So people call my office and say, Steve, the Consumer Protection Act says I should be able to do this. Yeah, it does. I go, you have to go read this other opinion by the Supreme Court and see what they say. And they'll tell you that you can't do that. So it's strange, but that really is the point. I've said all along, go to your legislature, get the law changed, or take it to the Supreme Court and see what they have to say about it. And they've spoken. Now, I do have to point out that this is actually an interesting intellectual exercise. And for anybody stuck into this video for this length of time, I salute you. But the law of 1945 was passed by a legislature and presumably signed by a governor. These things happen. This current sitting legislature in Michigan is part of the legal actions that were filed to get this before our current Supreme Court. So that means that, on some level, this legislature is saying, we want the court to overturn a previous legislature. And as I pointed out earlier, discussing what the Supreme Court wrote, there's this delegation of authority in the Constitution that says courts do this, legislature does this, the executive does this. What is that when the legislature goes to the courts and says, we want you to overturn a previous legislature? How different is that than the delegation of authority problem that the court found with the legislature giving power to the governor? Now the legislature is asking the court to overturn a previous legislature. Again, I'm not saying it's right or wrong. I'm saying it's good intellectual exercise. Okay, these are the things we think about. So you wonder what they talk about in law school for 2 years or 3 years. Most schools are 3. This kind of stuff, because it's interesting. So as of right now, the Michigan Supreme Court has ruled that the old Emergency Manager Act is unconstitutional, and the newer one, while still out there, was used up when the governor's extension when her extension expired at the end of April. Okay, so that's done. So now people say, but wait, Steve, does that mean that I wake up this morning and I can run out with a face mask and run into a store and do anything I want? No, 2 things. First of all, there's a 21-day period before this order takes effect. And you might wonder why that is, but there are court rules that say that anybody who's in front of a court gets a ruling, they've got 21 days to either appeal it or request for a rehearing, or there's a bunch of other procedural things you can do. And so in allowance of that, they basically say the order won't take effect for 21 days, just in case. Now, the odds of anything like that happening in this case are very slim, but theoretically they could, so it's there. But the other thing to point out, and it's in one of the footnotes, and I missed it as I was going through here, but there are departments of our government, like Health and Human Services, that have the power to issue rules and regulations. And many of the things that people have been complaining about the last few months were parts of executive orders, but some of them had come down through different departments. So for instance, I had several people ask me, what about the barber? There was a barber in Michigan who was defiantly cutting hair in contravention of this order. And he got in trouble for that. But although the executive orders mentioned hair cutting and so on, my understanding is that the department in Lansing that oversees people who cut hair had also issued an order saying you can't cut hair. And of those 2, that's the one I'd worry about more, because they're the ones who control the licensing. So, if there are other departments out there that have issued their own orders, this Supreme Court ruling does not affect them. This Supreme Court ruling only affects the executive orders issued by the governor after the end of April of this year. Okay? So it's going to be back to the drawing board for her, and hopefully she can sit down with the legislature and they can work out something. I hope they can. I can dream, can't I? But beyond that, she still runs a portion of the government, and a portion of the government that she runs that falls underneath the executive branch. That's my little drawing of the triangle of the 3 powers. The departments that she runs can also issue their own rules and so on. And so it'll be interesting to see how that plays out, because some of the stuff that's out there, obviously she does not control, but some of it she does. So we'll see what happens. But as of right now, the executive orders issued from Lansing by the governor have been deemed unconstitutional to some degree by the Supreme Court, and the others were deemed to have been unlawful due to the interpretation of the later of the 2 acts. But ain't nothing going to happen for a couple weeks. In the meantime, other actions might take place from other departments. So that's it in a nutshell. And by nutshell, I mean a very, very long video, for which I apologize. I hope you understood everything. Questions or comments, put them below. Let's talk to you later. Bye-bye.
Thank you for watching Lehto's Law. Start where you are. Use what you have. Do what you can.